Hashtag how to sue someone, small claims court guide. Every single day, millions of Americans deal with situations where someone owes them money, damaged their property, or broke a promise that cost them real dollars. Maybe your landlord refuses to return your security deposit. Maybe a contractor took your money and never finished the job. Maybe someone rear-ended your car and their insurance company is dragging its feet. You know you're in the right. You know money is owed to you. But hiring an attorney feels expensive, complicated, and frankly, completely out of reach. Here is the truth that most people don't know: you don't always need a lawyer. Small claims court exists precisely for situations like yours, and today we are walking you through exactly how to use it. Hashtag background. What is small claims court? Small claims court is a special division of the civil court system designed specifically to resolve disputes involving relatively modest sums of money quickly, affordably, and without requiring legal representation. The entire concept was built around accessibility. Lawmakers recognized decades ago that ordinary people needed a legal venue where they could resolve everyday financial disputes without spending more money on attorneys than the actual claim was worth. Every single state in the United States has a small claims court system, though the specific rules, limits, and procedures vary significantly from state to state. In California, for example, individuals can sue for up to $10,000 in small claims court. In Texas, that limit jumps to $20,000. In states like Kentucky and Rhode Island, the limit sits closer to $2,500. The national average falls somewhere between $5,000 and $10,000. These limits matter enormously because they define whether small claims court is even the right venue for your specific dispute. The types of cases small claims courts handle are surprisingly broad. Common cases include landlord-tenant security deposit disputes, which represent one of the most frequently filed categories nationwide. Disputes with contractors or service providers who failed to deliver promised work also fill court dockets regularly. Unpaid loans between individuals, property damage claims, defective merchandise, and minor car accident disputes round out the majority of small claims filings. What small claims court cannot handle includes criminal matters, family law cases like divorce or child custody, cases involving injunctions ordering someone to stop doing something, and any dispute that exceeds your state's monetary limit. Hashtag main content. The step-by-step process. Understanding how to actually file a small claims case is where most people get stuck, so let's break this down into clear, manageable steps. Step 1. Determine if you have a valid claim. Before you file anything, you need to honestly assess whether you have a legally sound basis for your lawsuit. Courts look for what's called a cause of action, meaning a recognized legal reason to sue. Common causes of action in small claims include breach of contract, where someone failed to fulfill a written or verbal agreement. Negligence covers situations where someone's careless behavior caused damage to your property or cost you money. Unjust enrichment applies when someone benefited financially at your expense without legal justification. Step 2. Send a demand letter first. This step is critical and frequently overlooked. Before filing in court, send the person or business you intend to sue a formal written demand letter. State clearly what they owe you, why they owe it, and give them a reasonable deadline, typically 10 to 30 days, to resolve the matter. This serves several purposes. First, it often resolves the dispute without court involvement at all. Second, it demonstrates to a judge that you made a reasonable good faith effort before litigating. Third, some states actually require a demand letter before you can file certain types of claims. Step 3. Identify the correct defendant. Suing the right party sounds obvious, but it's an area where many people make costly mistakes. If your dispute involves a business, you must identify whether that business is a sole proprietorship, a partnership, a limited liability company, or a corporation. Each structure affects who you name as the defendant and how you serve them with legal papers. Suing a corporation under the wrong name, for instance, can result in your case being dismissed entirely. Step 4. File your claim. Visit your local courthouse or, increasingly, the court's online portal. You will complete a plaintiff's claim form, which asks for basic information including your name and contact information, the defendant's full legal name and address, the dollar amount you are claiming, and a brief explanation of why you are owed that money. Filing fees vary by state and claim amount but generally range from $30 to $100. Keep copies of absolutely everything you file. Step 5. Serve the defendant properly. This is a step where procedural errors can derail an otherwise strong case. The defendant must be legally notified that they are being sued. This process is called service of process. Depending on your state, acceptable service methods include certified mail with return receipt, having a sheriff's deputy deliver the papers, using a professional process server, or in some states, having anyone over 18 who is not a party to the case personally deliver the documents. Improper service is one of the most common reasons small claims cases get delayed or dismissed. Step 6. Gather and organize your evidence. This is where you win or lose your case. Judges in small claims court see dozens of cases every single session, and they make decisions quickly based on the evidence presented. You need to compile every piece of documentation that supports your claim. This includes written contracts, text messages, emails, photographs of damaged property, receipts, invoices, bank statements showing payments made, and any written communications with the defendant. Organize everything chronologically and create a clear, logical narrative. Step 7. Prepare witnesses if applicable. Witnesses can significantly strengthen your case when documentary evidence alone is insufficient. If a neighbor watched the contractor leave your property with materials they never installed, that person's testimony has real value. Most small claims courts allow you to bring witnesses, and some allow you to subpoena reluctant witnesses to appear. Prepare your witnesses by reviewing the facts of the case together and reminding them to speak only to what they personally observed. ## deep dive. What happens in the courtroom? Walking into a courtroom for the first time can be intimidating, but small claims court hearings are intentionally designed to be informal compared to regular civil proceedings. Most hearings last between 10 and 30 minutes. There is no jury. A judge, or sometimes a court commissioner, hears both sides and makes a decision, often on the same day. When your case is called, you will have an opportunity to present your case first as the plaintiff. Speak clearly, stay focused on the facts, and reference your evidence directly. Hand copies of all documents to the judge. Stick to what is legally relevant. Judges have little patience for emotional tangents or irrelevant personal grievances. State what happened, show the evidence proving it happened, and explain exactly what you are owed. The defendant will then have their opportunity to respond and present their own evidence. After both sides speak, the judge may ask clarifying questions. Then comes the ruling. In some courts, the judge announces the decision immediately. In others, you receive written notice of the judgment within a few weeks. ## analysis. Winning is just the beginning. Here is something critically important that many first-time plaintiffs completely fail to anticipate. Winning a judgment in small claims court and actually collecting the money you are owed are two entirely separate challenges. A judgment is essentially the court's official declaration that someone owes you money. It does not automatically move funds from their bank account into yours. If the defendant does not voluntarily pay after a judgment is entered against them, you must take additional steps to collect. These collection tools include wage garnishment, where a portion of the defendant's paycheck is legally withheld and sent to you. Bank levies allow you to direct a bank to freeze and transfer funds from the defendant's account. Property liens can be placed on real estate the defendant owns, making it impossible for them to sell or refinance without first paying your judgment.